So we will hear your arguments. Each side will have 15 minutes, and the appellant may reserve up to 5 minutes. And just let me know.
Thank you. If I can indicate that to you now, I would reserve 5 minutes.
That's fine. You may approach. Come on.
Hey,
This one is the one we use because we're going to be videotaping this as we do when we put it on YouTube. So seeing that, one of the things I want to caution both sides is to use initials or refer to the child as the child and not by the child's name, as well as refer to father as father and not by name, mother, etc. Try to keep confidentiality as much as possible. Okay?
all right,
All
thank
right.
you.
We're ready to listen then. You may proceed.
Thank you. If it pleases the court, Judge Carr, Judge Callahan, Judge Theodosio. My name is Carol Horvath, and I represent the father in this matter. He is the appellant, and I thank you for the opportunity to come and speak to you with regard to this case today. I would indicate that there are 4 areas that I hope to speak on today, but first I'd like to briefly discuss the facts of the matter. The child was born October 19th of 2009, and the parties in January of 2013 had worked out in A.W.P County Juvenile Court an arrangement wherein visitation was established, and shortly thereafter, my client, the father, came in and filed a motion to show cause in March of 2013. I would make the argument that this particular matter concerning this child and visitation was a case that was a highly conflicted case between the parties, that the record shows that after visitation was established, there were immediate conflicts. There's a situation where my client, the father, was instructed by the mother not to communicate or talk with her, and instead he should handle everything and deal everything through the mother of the child. Situation didn't get any better. The parties stopped communicating via email. Instead, there was a system set up where there were 2 telephone numbers for my client to call stepfather. And at some point in time, right around June or July of 2013, I believe the transcript will show that both of those phones were shut off. So with regard to child support, the facts would show that there was never an order established. And both parties' testimony indicates it was discussed in the County Juvenile Court. However, the mother indicated that it was not necessary, an order was never established. Instead, my client gave up the income tax exemption, and from there, he was not under an obligation per se to go ahead and pay any sort of child support at all. I would indicate that one of the major issues or concerns in this matter is the fact that my client became incarcerated. I believe the first day that he went to prison was June 13th, or in June of 2013. And from that point in time, he lost the ability not only to support financially if necessary, but that he also was unable to communicate. One of the issues of particular concern is the fact that he is attempting to defend the adoption proceeding from prison. And he had requested motion for continuance on March 10th of 2016, filed it with the court. He did not receive a response, was finally able to find counsel, retain counsel on March 24th, and then a notice of appearance was filed March 28th of 2016, and the hearing was held March 29th. So it is his contention that with that timeline and the court's failure to allow him continuance so that he would be able to obtain counsel, that he was disadvantaged, that there was very little time for him to communicate with counsel, that he was unable to effectively locate documents which may have been important in the hearing, such as possible receipts for funds expended on the minor child. In addition, he was unable to allow counsel to see and perhaps request the court to admit emails, responses to emails that were in the email thread between the parties to show the types of conflicts that they were having and the types of issues that they were discussing.
But counsel, didn't your client actually have what you call the power of a court order behind him? I mean, the initial agreed visitation, which I understand wasn't agreed upon for too long, that was adopted by the court, correct?
Yes, Your Honor.
And he apparently knew that he could utilize the court because he filed a show cause at one point, I think maybe twice. They were subsequently dismissed, but he did go to the court to do that, correct?
Yes, Your Honor, he did.
So despite these, the facts you're putting in your brief about what we call the interference with his contact, he could have gone to the court, couldn't he have?
Your Honor is correct. He could have. He certainly had filed in 2013 a motion to show cause. He would have been able certainly to refile it. I think in the transcript he gives some reasons why he did not. He clearly was unable to contact child's mother. And at that point in time, I think his life probably became somewhat more complicated with regard to issues that eventually resulted in him becoming incarcerated. It certainly would have been much better, and I would have had an easier case to argue had he gone ahead and filed a motion to show cause and pursued it. And I understand that it is indeed a two-pronged test, and that particular fact probably points more towards the de minimis contact than it would the financial issues with regard to this case. All I can say is that he had indicated in the transcript that he didn't desire to visit, that there clearly was interference with regard to his ability to see the child. He, at one point in time, did not have email contact or the ability to email. He was told not to contact the stepfather. The mother, just to contact the stepfather. And there is some indication in the transcript that there may have been some threats passing back and forth between father and stepfather. I believe there is admitted into evidence his affidavit in the motion to show cause where he delineates some threats. So I think it's fair to state that he probably felt uncomfortable dealing with stepfather. The court's order, juvenile court certainly would have indicated that he should deal with the child's mother, and she, I believe, by court order would be under an obligation to go ahead and facilitate visitation to the extent that she could. Nonetheless, it would have behooved him to go ahead and file, but he did not. And I think there probably were a number of reasons, both personal and otherwise, to indicate why he did not do so. I think there is one point in the transcript where there's a suggestion about going to perhaps using the Domestic Violence Center as a place where visitation could take place appropriately. And the question factually for this court will be, do the facts and circumstances rise to justifiable cause for his failure not to have contact with the child during that time period. All I can indicate to the court is that it was a very short period of time when the phones which were available were cut off. I think it was shortly after he had filed his motion to show cause in 2013, and then in June and July of 2013, I believe that those numbers, or at least one number, was no longer available to him. Certainly the argument could be made that, you know, he knew the address where the child was residing and could have gone there and, you know, demanded to see the child, or perhaps use the assistance of the police to do so. He did not do so. I think part of it may have been that he felt somewhat threatened. I think part of it may be what he had personally going on in his life at the time. I also think that part of it may have been that he felt the child was 6, and perhaps that wasn't a particularly good idea at that point in time to do so.
Counsel, you're into your rebuttal time.
Thank you. So with that, I would merely state to the court that I feel that my client was denied due process by being unable to present his case properly, and that would be the chief issue that I would indicate to the court. Thank you very much.
Please the court, your honors, my name is Betty Burley, and I represent stepfather, who is the petitioner in this adoption case. I believe mother's name is listed as the appellee in this case. Mother is married to my client. Indeed, I represent them both. I would agree with opposing counsel's characterization that this has been a very high conflict relationship from child's birth. The child was born in October 2009. Father filed a first application to determine custody in Cuyahoga County in November of 2009, and subsequently dismissed that action in April of 2010. Came back a second time to juvenile court in Cuyahoga County in July of 2012, and filed an application to determine custody, and entered into an agreement in January 2013 that was adopted by the court in February of 2013 that gave rise to a visitation order that's still enforceable at this moment. Subsequently, before that agreed entry was entered, my client and A.W.P. and his mother moved to Vermilion, the Lorain County site of Vermilion. That address is reflected on the visitation order. I would like to correct some issues in the timeline. Opposing counsel stated that both phone numbers that were provided to her client were shut off, and the fact of the matter is one of them, which was a pay-as-you-go phone, was shut off after several months of father not availing himself of use of that. It was bought specifically for father to call to exercise his right to phone visitation with the child. The other phone number provided to him was stepfather, my client's telephone number, and that remains in service today. That was never disconnected. As Attorney Horvath has indicated, father had a good address for mother, and indeed the last email conversation that mother had with father was father indicating that he was terminating all visitation until such time as his show cause motion would be heard in Cuyahoga County Juvenile Court. Father subsequently, without explanation, filed to dismiss that motion. And that was the last communication that mother had with father until the consent hearing in March of 2016. opposing counsel has stated that father was incarcerated in June of 2013. That is incorrect. The record reflects that father was incarcerated in June 2015, 2 full months after the petition for adoption was filed in Lorain County Probate Court. As stated, this has been a rather high conflict situation from the beginning. My client concedes that mother advised father not to contact her by telephone anymore. The record reflects that the two agreed that there were arguments that were taking place, and father's email to mother stated that the argument wasn't good for A.W.P, and that's when he had made several suggestions regarding changing the very new order. Those were never given the opportunity to be heard in front of the court. Mother did try to facilitate visitation by agreeing that the two meet at Vermilion Police Department to exchange possession of the child at the appointed time. At no time did mother ever refuse visitation to father. Mother testified that there were no letters received. Father testified that he had sent mail, but also testified that there had been no mail received, returned to sender. He indicated that he wasn't sure that mother was still at that address, but couldn't cite to any investigation that he had done. He admitted that he didn't contact law enforcement to do a welfare check or any agency. Moving to the child support leg, my client denies that there was ever an agreement to forego child support in exchange for the income tax deduction. She states that that wasn't a conversation that they had. There was no order for child support in the Cuyahoga County order. There was not a no support order or a zero support order. The issue just simply was not addressed. Moving to the due process claim of appellant. It's true that he did file a motion for continuance, which was denied by the court. I would note that my client was not served with a copy of that motion as required. And so we appeared on March 26th for the consent hearing. Both parties had taken off work at considerable expense and inconvenience. The magistrate in his decision indicated that the appellant himself had contributed to the circumstances giving rise to the request, which was one of the factors listed in State v. Unger as to the court, that the court should review in determining whether or not denial of such a motion is a denial of due process. Another issue raised in appellant's brief was that the probate court had no jurisdiction to hear the adoption case, stating that there were pending motions in Cuyahoga County Juvenile Court. I do believe that the appellant submitted a copy of the juvenile court docket. It's included in the record that was submitted to the court. And prior to the date that which was April 16, 2015, that my client's petition for adoption was filed. The last prior entry on that docket was dismissal of father's show cause motion in 2013. 10 months after the petition for adoption was filed in Lorain County, paternal grandmother and father's adult daughter filed motions to intervene in the juvenile court case in Cuyahoga County for their own visitation order. Those were filed 10 months after the adoption petition. There were no motions pending in any court on the date the adoption petition was filed. Does the court have any questions about the facts or the laws applied in this case?
Evidently not.
Okay. Then I thank you for your time and your attention, and I ask that the court would uphold the probate's decision that, that appellant's consent is not required to proceed with his adoption. Thank you.
Thank you.
Thank you. First, I wanted to indicate that Ms. Burley is correct. I misspoke about the date that my client was incarcerated. It is 2015. And I may have misspoke about the two phones being off. I believe I took that from a footnote in the appellee's brief. But what, I guess, overall, what I would want to argue to the court is simply the fact that my client didn't have the opportunity to consult with counsel and be able to find exhibits and present them to the court to show the facts concerning why there was no financial support, and also the source of the interference and what his email attempts may have been to deal with that, I believe prejudiced him. And I would argue and ask that the court consider remanding this to the trial court to give my client another opportunity to see if he can find those documents and be able to fully present his case. I know often these cases turn on the facts from case to case. In this matter, I would certainly indicate that from a financial standpoint, there's documentation and testimony in the transcript that mom said it wasn't necessary to have the child support. And certainly there was no order, and I'd ask the court to take that into consideration. And further, I would ask the court to look at the testimony concerning the interference and the conflict that has taken place between the parties, and consider that also.
Do you agree that there were no unresolved motions pending when the adoption petition was filed?
Yes, Your Honor, I
You
do.
do agree with that?
So, I would simply ask the court to take the evidence into consideration and consider the facts as presented as they relate to interfering with the ability of my client to visit, and also the fact that there is no order upon him to actually provide financial support. He may have been able to come up with receipts and so forth to show that he had attempted to forward gifts and so forth to the child, but he was unable to do so given the timeline before the hearing. And by the same token, he may have been able to show whether interference, but was unable.
What was the time frame prior to the hearing that he would have had an opportunity to retain counsel or request counsel?
Well, Your Honor, I know that he pro se filed the motion March 10th, asking that he be given an opportunity to obtain counsel.
How long had the matter been pending at that time?
I believe that there was an indication that April 5th of 2015 was the date the adoption petition had been filed. To the
And
best
this
of my
request
knowledge.
was made March 10th
Yes.
of 16?
Yes, Your Honor. And he had contacted me, I believe it would have been maybe around March 24th or 25th. That would have been approaching Easter weekend, and then I filed my notice of appearance Easter Monday, and we had the hearing the 29th immediately after. So my comments are clearly based upon that shorter time frame from March 10th to the 29th, the date of the hearing.
Was he represented at in any other proceedings by counsel?
I don't believe so, Your Honor.
How about when you said he was incarcerated at some point in time?
Yeah, yes, Your Honor, he would have had criminal counsel, I'm sure, based on the charges and the fact that they were felonies, that he would not have been able to get through the system unless counsel was appointed
Sure.
for him, or that he would have counsel that would
All right,
make
thank you.
sense. All right, thank you very much for
Thank
your
you.
time.
Thank you both for your presentations to the court. The court will take the matter under advisement. Any written opinion will be sent to both sides, and we will also release it on our court's website. And with that, the court is adjourned until Thursday.